Are there legal loopholes for negligent property owners? When someone gets hurt on another person's property, it can seem straightforward. Someone was negligent, and they should be held responsible. But in reality, the law has many rules that can make it tricky to prove liability. Property owners have a duty to keep their premises reasonably safe for visitors. If they fail, and someone gets injured, the injured person might seek compensation. But property owners can sometimes find ways to limit or avoid responsibility. Let's look at how this works. First, for a property owner to be held responsible, main things need to be proven. 1. The owner had a duty to keep the property safe. 2. They failed to do so, which is called a breach. 3. This breach directly caused the injury. And 4. The injured person suffered damages like medical bills or lost wages. If any of these are missing, the owner might not be liable. States set time limits called statutes of limitations for filing these claims. If someone waits too long to act, the property owner can escape liability. These deadlines vary. Some states give as little as 1 year, others up to 4 years. Missing this deadline is a common way property owners avoid responsibility, even if they were negligent. Another factor is how the law views the injured person's own fault. In some states, called contributory negligence states, if the injured person is even slightly at fault, they might recover nothing. For example, if someone slips on a wet floor but was texting and not paying attention, the owner might argue the person shares blame. Other states use comparative negligence, which reduces the compensation based on how much fault the injured person has. So if they are 50% at fault, their award is cut in half. Property owners can also defend themselves by showing they didn't know about the hazard or didn't have enough time to fix it. For instance, if a spill just happened moments before someone slipped, the owner might not be considered negligent. The law expects owners to know or reasonably discover hazards and fix them promptly. In rental situations, responsibility can get complicated. Leases or property management agreements often specify who is responsible for maintenance and repairs. If the lease clearly states that the landlord or manager is responsible, the other party might avoid liability. Courts look at these agreements and state laws to decide who is liable. For someone injured, acting quickly is essential. Taking photos, gathering witness statements, and collecting medical records help prove negligence. Because statutes of limitations are strict, delaying can ruin your chance to recover damages. Consulting a personal injury lawyer early can help you understand your rights and avoid losing your case due to legal technicalities. In the end, while property owners are generally responsible for injuries caused by their negligence, several legal rules and practical issues can limit their liability. Laws about how long you have to file, rules about how much fault you share, and specific details about property management all serve as potential loopholes. Knowing these rules and acting fast with strong evidence can make a big difference in holding negligent property owners accountable.